Good afternoon, everyone. Thank you for coming on this beautiful fall afternoon. This past week, libraries and booksellers around the country celebrated Banned Books Week, which is an annual event celebrating the freedom to read. It highlights the value of free and open access to information, and it brings together an entire community of librarians, booksellers, publishers, journalists, teachers, and readers in shared support of the freedom to seek and express ideas, even though some consider unorthodox or unpopular. So it's fitting that today we have Floyd Abrams, author of The Soul of the First Amendment, and Vince Blasi, the Corliss Lamont Professor of Civil Liberties at Columbia Law School, as they discuss our First Amendment rights. Before we begin our program, I'd like to just thank a number of our sponsors who have contributed to make this event possible, especially Susan and Thomas Dunn. And Susan's here. Wave, Susan. Thank you so much for your support of this program. We also have received funding from the Montclair Foundation and Investors Foundation. And tonight's event in particular has received support from the law firm of Trunk, DePasquale, De La Fera, and Sedona. So we thank them for their support. If you enjoy the programs we offer, we encourage you to support the Montclair Public Library Foundation, and information on how you can do that is available at the registration desk. We have two more Open Book, Open Mind events scheduled for this year. On October 13th, Katie Tur and Tom Johnson will be in conversation, and that's a free and open event. November 8th is Isabel Allende with Christina Baker-Klein. That is a ticketed event, and tickets are still available for that. We'd also like to invite you to join us for one of our community forums as we plan for the future. On Wednesday, October 4th, this Wednesday, at 7 o'clock here at the main library, and next week, Tuesday, October 10th at 7 o'clock at the Bellevue Avenue branch, we'll have some facilitated conversations about the future of the library, the services we offer, and the programs that we have, to encourage all of you to try and attend one of those if you can. So, before I sit down, please remember to turn off your cell phones. Dave Jones will come up, and he's setting a great example. And I'd like to introduce Dave Jones, who's the co-creator of the Open Book, Open Mind series and a former Library Foundation trustee. His support of this program has been invaluable. And I also encourage you afterwards to purchase a book from Washington booksellers in the lobby. They'll be signing and taking questions at the end. So thank you all for coming this evening, and David Jones.
Thanks, Peter. We're really greatly blessed this evening to have such distinguished guests, Vince Blasi from Columbia and Floyd Abrams. And it's a particularly timely moment to be concerned about First Amendment issues. Vincent, as Peter said, is the Corliss Lamont Professor of Civil Liberties at Columbia. He's an expert on constitutional and First Amendment law, and he's been on the Columbia faculty since 1983. He has a BA from Northwestern and a JD from the University of Chicago, and he's been on the faculty of the University of Michigan Law School, the University of Texas Law School. He's been a professor at the University of Virginia Law School, and a visiting professor at Stanford, Berkeley, and William and Mary. Floyd is officially senior counsel of Cahill, Gordon, Rundell, a New York law firm. But the fact is that he's arguably the preeminent First Amendment lawyer in the United States. Some years ago, Daniel Patrick Moynihan described him as the most significant First Amendment lawyer of our age, and since then nothing has happened to diminish that reputation. His career has been involved, he's been involved in his career with a wide array of First Amendment cases, which are too long to mention here. I see his career as bracketed basically by the Pentagon Papers case in the New York Times in 1971, where he was co-counsel for the New York Times in that case, and the recent ruling by the Supreme Court on Citizens United, where he was counsel to Senator McConnell in the victory for the Citizens United case. Between that time, he's represented many prominent media companies, including New York Times, which is where I first met him, ABC, NBC, CBS, CNN, Time, Business Week, The Nation, Reader's Digest, McGraw-Hill, and so forth and so forth. I think you get the idea. He has a BA from Cornell, JD from Yale Law, been a visiting lecturer at Yale Law, on the faculty of Columbia Law, a visiting professor at the Columbia Journalism School, and is now an adjunct professor at NYU. He's a member of the American Academy of Arts and Sciences. His awards and honors are too numerous really to mention. As you know, he's here on the occasion of the publication of his second book, which I hope, if you haven't read it, you'll buy. This is over. You can read it. It's quite a compelling discourse on the First Amendment. And I would just say that I consider him to be a legal scholar who has shaped American understanding of the First Amendment rights. And we're very privileged to have him, so please welcome Vince Blasi.
I have the very welcome assignment to start the conversation. I do want to say it's a great honor to be on the same platform with Floyd. I can up the ante and I can say I said this in print, I'm just not making it up for the occasion. I think he's the most important First Amendment lawyer in the history of the country. I really mean that. We go back a long way. We team taught a seminar for a couple of years in the early 80s at Columbia. We testified on opposite sides before the Senate committee on the question of regulating cigarette advertising. I have a lengthy excerpt from one of his earlier books in my case book that I use in teaching my First Amendment course. I'm devoting an entire 2-hour session in a couple of weeks in my seminar to this book. So I've really watched his career with great admiration. I've watched him try a case, not just argue appeals. I just learned so much from him over the years, so delighted to be here. I'm also delighted to be in Montclair for a reason. You probably heard things like this before, but one of my real heroes in life is Yogi Berra, who, you know, is a distinguished Montclair, or was a distinguished Montclair resident. But you probably don't know his connection to constitutional law. There's a very creative scholar at Yale years ago who wrote an article arguing that you can understand the Supreme Court by understanding baseball. And his claim was that certain baseball careers are analogous to certain careers of Supreme Court justices, and you can learn by the comparison. And when he illustrated that point with Yogi Berra, his point of comparison was Chief Justice Earl Warren. Offended all the purists, swung at a lot of bad pitches, but he's the man you want in the batter's box when the game is on the line. The greatest RBI man in history. Anyway, Floyd, let me start. I was surprised by this book. I read your earlier books, and I always would have thought that you and I would map somewhere near the same place on the spectrum of how you think about free speech and the various arguments for regulating speech. And I was surprised when you said in the book that you changed your mind about campaign finance, the issue in Citizens United, in 1990 when you read Justice Scalia's dissenting opinion in an earlier case, and that his argument led you to believe that regulating corporate or union spending in elections was more problematic than you once did. And I also felt in reading this book that you were taking stronger positions, more principled categorical positions against the regulation of speech than I had previously associated you with. And so I just wonder if this book represents a kind of culmination of an evolution in your thought about how to think about the First Amendment.
Well, first, thank you all for having me here. I give myself too much credit by saying that Justice Scalia's opinion changed my mind about campaign finance regulation. I hadn't thought about it a lot, and I was very much on the side. I suspect that most of you, or certainly most of my friends with who tend to share political views, that you know, too much money, too few people, too much power, too little regulation, ... But I hadn't really focused on it, and there hadn't been many cases as such dealing with it until this case, which involved a law in Michigan, which basically made it illegal for corporations to weigh in financially with respect to referenda that were being decided in the state. And it just seemed to me that I'm reading the opinions, and again, it was my first real exposure to this area, that on reading them, that Scalia just had much the better of the argument. But we can come back to that when we talk about Citizens United, as I'm sure we will later. But more broadly, yes, it does reflect a more general change in my opinions. When I was in college, I was very persuaded by what I'll call English law. English law today, as well as then, that they have no written constitution there, they have no Bill of Rights, therefore, there, and they're a very free country. But if a journalist publishes something about an ongoing criminal case which contains a confession which has not been admitted into evidence, that's a contempt of court. Journalists go to jail for that. If a journalist publishes information about a prior criminal record of a defendant, which is inadmissible in court, that's a contempt of court there, and it's free speech here. And when I was in college, I thought it just made sense. In order to give someone a fair trial, well, why should these things be allowed to be said? And I started to move then, and then moved much more quickly after I was graduated from college and even graduated from law school, towards being much more concerned about the power of government to limit speech than the question of whether this speech or that speech was useful or not useful, or important or not important, or even potentially harmful, at least up to a point. And so, yes, I mean, I have come to a point now where I do look for, if it were, you know, if it were my First Amendment, require much more, much firmer lines, much more rigid ones. Some areas we can't have them. I believe in having libel law, for example, but we have the most pro-press libel law in the world. You have to prove more here. You have to overcome much greater barriers here, and I'm all in favor of that. And I'm in favor generally, and have come to be more in favor generally, sort of as, you know, as I get older, or as I look around the world, and I see the degree to which governments in one country after another have stripped people of their freedom, sometimes slowly, sometimes more quickly, sometimes by revolution, by the imposition of rule by the government Now, here, we treat courts as government, too. They're government employees. They have the power of the army, of the police in back of them. So taking the government as a whole and viewing what's happened elsewhere in the world and viewing what often used to happen here in this country, it has seemed to me that we needed very strong protection against the government and the First Amendment, and the Bill of Rights generally, but the First Amendment in particular is the place in which one finds that sort of strong resistance to government involvement and engagement and oversight. And it's not in every case, and there are exceptions, but we live in a country which, as a legal matter, is freer by far than any other country really in the history of the world. We pay some price for that, which we can talk about, but I think that's a good thing, and that comes from the First Amendment and the interpretation of the First Amendment, which really began in the last century.
I will say that, to me, the book was very powerful in the examples that you relate about regulation of speech, say in Europe, but also in earlier years. You recount in the book how you read various accounts of censorship starting from 1900, throughout the 20th century. The jaw drops when you see what was regulated routinely without anybody worrying much about it in the early years of the 20th century.
Complete artistic censorship, for example, here in our country. I mean, I had occasion to write an introduction to a book of New York Times clippings in the 20th century on censorship around the world, but including here. And so just reading old clippings, written straight, not tongue-in-cheek, this is what happened yesterday. The book Ulysses, coming out, the publisher of Ulysses, being hauled in front of some New York State Supreme Court judge in the 1920s and jailed briefly for getting the book into the country at a time when it was illegal to mail it. The mails wouldn't carry it. And one case after another, Pennsylvania had cases where there used to be Perils of Pauline movies, when they had silent movies, where there was a young woman tied to the railroad track and the train was coming. It was banned. It was a crime. It was illegal. Why? Because it was bad stuff. It could lead children to do bad things. It could teach bad lessons. You could wind up with a worse society. And it's that sort of thinking which permeated American life. And I must admit, notwithstanding the fact that there was a First Amendment, it just is not the same First Amendment that we have. One more example. From the New York Times, circa 1900, a newspaper held in contempt for publishing the, quote, details of a hanging, unquote, because whatever state it was made it a crime to publish anything about a hanging, which might make you against capital punishment or sympathetic to the guy being hung or hanged. And I was struck. I mean, all the more so reading it on the printed page, that it wasn't written, as it probably shouldn't have been journalistically, tongue-in-cheek, or would you believe this? This is what happened, and that happened, that happened. And it's a very good lesson for what censorship can do. Very often, well-meaning censorship for one public purpose or another. but really very harmful, and in the end, very threatening, because when really important stuff, not the details of hanging, are at issue, then you have legal precedent which allows terrible deprivations, 1984-like deprivations of free speech.
Now, I have a grievance, and you're only a minor source of my grievance, but let me
I plead guilty.
let me explain it. Most persons who have views that overlap a lot with yours about needing a robust First Amendment, even when the speech seems hateful or, in certain ways destroying the balance of public debate, assert that the text of the First Amendment leads them to that conclusion. Congress, and as a result of the 14th Amendment, states shall make no law abridging the freedom of speech. I believe that the text says something different than it would if it said no law regulating speech. Abridging is an important concept, and it's not, or no law regulating speaking. It's not just speaking that's free, it's the freedom of speech, an historical concept, something that came to be prioritized for historical reasons. Now, your reasons about building huge barriers and assuming the worst about every would-be regulator are based on experience, and you document them with examples, and it's not a kind of textual literalism or a almost tribal, whose side are you on? Are you a friend of the First Amendment or not a friend of the First Amendment? Now, I happen to be somebody who thinks of himself as a strong friend of the First Amendment, but who is inclined not to think that it covers every conceivable use of words. So recent cases about deliberate lying, that you were a Medal of Honor winner, or crushed videos of animals being tortured, or violent video games of teenagers. I don't think it's self-evident that just because those means of communication involve words or pictures, that it's all of a sudden in the domain of the First Amendment. That believing that the First Amendment needs to be robust doesn't mean it needs to be far-flung and loosened from its historical moorings in terms of, my particular interest is the history of thought about free speech, studying people like John Milton, James Madison, John Stuart Mill, the early superstar judges, Leonard Hand, Oliver Wendell Holmes, Louis Brandeis. They were all talking about serious exchanges of ideas and not the sort of outer edges of getting attention by doing outrageous things and the like. So, where we disagree, I think, is in, you have different reasons. They're not just literal, but they're historically informed about wanting an expansive as well as a highly protective First Amendment. But it seems to me that if you can make an exception for libel, and particularly when it involves private figures, where we do allow punishment for false defamatory speech that injures reputation if the speaker is negligent, that allows a certain amount of regulation of speech. If you can allow that, then it seems to me that you at least ought to be open to other kinds of regulatory interests that I think from the book you're very wary of allowing to be reasons for regulation. One example you talked about a lot in the book is speech outside an abortion facility. After the first wave of Operation Rescue crowds and a certain amount of physical intimidation, some states thought it was necessary to create kind of bubbles, free zones where protesters couldn't come too close to women entering abortion facilities. Now, some of the protesters, some of them were threatening by design, but there were others that were convincingly presenting themselves as sidewalk counselors with a moral objection, needing a quiet conversation at the only place where they'd be able to reach the person to try to persuade her not to take what they thought was a human life. I understand all that, but it seems to me it's just a hard case in terms of how you balance those interests. And I think many justices, and I think from the way you discuss it in the book, don't view it as a hard case. And there are other examples I could put forward, but so say a little more about why we have to have such hard and fast rules and no room for these kinds of regulatory arguments.
Look, this is not always an easy area. We have a long history as a country. We have a Bill of Rights adopted with language which is subject to debate as to precisely what is meant, not just by abridgment. I had a debate with then Professor Scalia before he was on the Supreme Court, in which he said the most important word in the First Amendment was the. No law abridging the freedom of speech, therefore meaning the freedom of speech as it was at the time the Constitution was written. That freedom of speech, the freedom of speech they had in England, that was the freedom of speech, he argued. I'm not a historian, and while I play around a little bit in the book, just on reading speeches of framers about certain aspects of the adoption of the Bill of Rights in general, and the First Amendment in particular, I don't usually get into the fray about whether they really meant everything. They could not have meant every single word, because perjury is a crime, right? You lie under oath, you go to jail. No lawyer, no great First Amendment lawyer is going to get up and say, we cannot make perjury a crime, even though it's words. And we have other areas in which historically obscenity, you could do a course, more than a course, just on obscenity law. But at least that too is historically rooted, and that's true in certain other areas as well. And in some areas, I mean, I read what the Supreme Court is saying is just throwing up their hands and saying, look, give me a break. No one ever thought that was protected by the First Amendment. And it's not just perjury. You lie under oath to an FBI agent, you go to jail. And there are a number of other examples. So it's, no, it's not absolute, it's not absolute. My view, though, is that it's important to keep it strict, to be very sure that freedom of speech is the rule and not the exception. And that the way to do that, as cases arise through the years, is to not yield, and certainly not yield easily, to claims that the First Amendment should be overridden. But do I agree that there are circumstances that, sure, I was in the Pentagon Papers case for the New York Times. We did not argue that in every possible circumstance that one could conjure up, that the government couldn't get a prior restraint. Indeed, there was language from a case in the 1930s talking about, well, if this was the sailing dates for warships, nobody would argue. That sounds so wonderfully antiquated, doesn't it? Sailing date. But the sailing dates for warships, well, sure, you could have a prior restraint on that, but it has to be that bad. And we tried the whole case saying, this is not a warship case. This is not like that. Read the materials, Judge. and you'll see that the Pentagon Papers, which was for any of you who had other lives, or no life at that time, a secret study, top secret, prepared during the war in Vietnam at the request of the Secretary of Defense, Secretary McNamara, who, as the war raged on, suddenly had the bright idea, why didn't we find out how we ever got here? So he commissioned a study of how we got involved in the war in Vietnam. And all of it was labeled top secret, every page, 7,000 pages. Daniel Ellsberg was one of the writers of it. He came to the view that our involvement in Vietnam was a war crime, and that the public had not been provided with very important information about how we got involved and the like, and made available to the Times those 7,000 pages. It was the biggest leak, incidentally, in American history, and talk about things being antiquated, when Mr. Snowden has millions of pages, which he either has or has not given to the Russians, depending on who you read. I can't make the argument, and wouldn't, that there are no circumstances in which speech can be limited. But it does seem to me that important to try to hold the line, to try to make it really difficult. And now, in the case of either abortion protesters or people who would like to be anti-abortion counselors, we're talking here generally about public streets, where the First Amendment has always been all but absolute, actually. You have a right to be on a public street, but you can't block traffic. You have a right to be on a public street, and you can't block access to an abortion clinic, or indeed any medical facility. An abortion clinic happens to be protected because the Supreme Court has ruled that it is by the Bill of Rights. But to me, it's very important to keep open the lines of communication of people who disagree with that opinion, and more important, who believe abortion is killing a child. I think that it is important that they be able to be heard, so long as they don't block access or threaten to harm women, even though it does make it more difficult and more potentially threatening, even if there are no actual threats voiced. So when I read about or personally sort of pass upon cases like that, yeah, I think it's very important that people who have a strong moral view on an important issue of public policy, like abortion, even though I happen to disagree with them, to try to have a shot at persuading women not to have an abortion. And as long as they don't get in the way, and so, sometimes they have, as long as they're not threatening broadly, it seems to me important to keep that sort of speech, as much as any, available and free to engage in.
So with the concession, you're not an absolutist, let's turn to Citizens United. After the case came down, many of you remember President Obama, in his next State of the Union address, was critical of the decision and claimed that its logic extended then to the right of foreign countries to participate in our elections, or foreign-controlled corporations. And Justice Alito, who was there for the occasion, was seemed fiercely shaking his head, misreading of the court's opinion. And of course, it's clear the court did say in Citizens United, we don't reach the issue, it doesn't extend to foreign involvement in elections. But it does seem to me that Obama had a point in terms of the logic. That is, there are two different justifications that Justice Kennedy gives for recognizing a right for corporations to use their treasury funds to make independent expenditures in election. One is that individual citizens can associate with others who share their views and leverage their communication that way, and they can use the corporate form to do that, including associating with for-profit corporations. And secondly, that the main rights here are the listeners' rights, and if some voters want to hear what corporations have to say on how different candidates compare, they ought to have a First Amendment right to hear from whatever would persuade them from whatever source. My claim, I suspect Obama's claim, is that the same logic applies to American citizens who want to associate with foreign citizens to magnify their voices, or American voters who want to hear any argument that can be made that might bear on their vote, even if it comes from foreign countries or foreign-controlled corporations. Can you defend the distinction, or is that the really expansive logic of Citizens United?
I just watched the Secretary of Treasury this morning being unresponsive on every network to various questions about the new tax plan. I would try to be responsive, but I just want to introduce this in this way. For me, Citizens United was an easy First Amendment case. If one was starting fresh and having just a brand new look at this, here's this case. What is this case about? A conservative political group at a time when it looked like Hillary Clinton would be nominated, and then Senator Obama, of course, was in 2008. But a conservative political group puts together a documentary, so to speak, really, I would say, a hit job, denouncing then Senator Clinton, with one person after another saying bad things about her, and one person after another saying in substance, she's not to be trusted, we can't let her be president, we have to do all we can to keep her from being president. It's a 1 hour piece of work. The statute at issue, the Kane-Feingold law and some other laws, when you put them together, basically said if there was any corporate money at all in this organization did get, actually not even a lot, but some corporate money. If there's any corporate money at all, but within 60 days of an election or 30 days of a primary, that you couldn't put on television, cable, or satellite advocacy of who to vote for and who to vote against. That's what the statute said. So this would have been a crime for this to go on television. They wanted it to be on pay-per-view. And there were legal arguments about whether pay-per-view is cable or television or nothing of the three. I mean, this is what lawyers have fun with. But you know, the core issue here, the core factual situation is they are a politically active group. They didn't want Hillary to become president. They wanted to say it in the most effective way, and they couldn't put it on television, and they couldn't put it on cable, and they couldn't put it on satellite at the time when it's most important to put on, which is close to an election. And the basic body of law we have generally had is that no speech is more protected than political speech, and that even within the realm of political speech, no speech is more protected than speech about who to vote for. For me, it was unacceptable to say that this piece of anti-Hillary advocacy was by its nature criminal, because any of the money that went into making it came from a corporation. And that is what the narrow issue of the Citizens United case was about. Now, we have a lot of rules in every body of law. And, you know, sometimes it's like three-dimensional or six-dimensional chess. So, yes, we have a rule such as I just said. Political speech is most protected, and election speech maybe is most protected. But what about foreign money coming in? You know, this is another body of law, perfectly rational, certainly that I support, saying we don't want foreign money in the same way we don't want what appears to have happened in the last election in terms of foreign involvement in our election process. I don't think that violates the First Amendment. I think it's different in kind. Can you make the argument, as Vince did, that, well, sure, if all you care about is that the public be informed, it doesn't make any difference who's speaking. Foreign speech is no less speech than American speech. But, you know, deal with that, I think, persuasively and effectively. You know, my starting point on Citizens United has always been that in this particular area, and in a way all the more so, because what the McCain-Feingold law, which had some aspects that I agree with a lot, but what they were most offended by, worried by, answering, is all these ads on television, the profusion, the explosion that overcomes us. And in some states, I happen to be in Ohio, you know, but New York and New Jersey, we don't get a lot of these ads. But you go to a state that has elections, like Ohio, and it's over and over and over, and the public goes crazy. They can't watch their programs. Everything is negative. To me, that's democracy at work. And to me, it's democracy at work to allow speech and more speech and more speech. Now, in the area of Citizens United, one more thought. I come to Citizens United having represented a lot of large corporations, including the New York Times when it was a large corporation, and other media entities, which had enormous power, a lot less now, but enormous power to shape elections and the like, and in which legislation was passed now and then to try to make things a little bit more reasonable. So Alabama passed a law at the end of the 1950s, at a time when most people got their information about the world from newspapers, and most towns in America had one newspaper. So Alabama passed a law saying on election day, just on election day, a newspaper couldn't say something in an editorial that was entirely new and hostile to a candidate, because he wouldn't have a chance to answer, which was true, but he wouldn't have had a chance to answer. And they said it's fair and it's democratic, because otherwise you just hear one side. And the Supreme Court was unanimous and said, we can't tell the press what to print. That's the answer. The government can't tell the press what to print. If they want to have something on election day, maybe you can italicize it, on election day, no less, that the government, even with some pretty good reason, can't come in and not allow it. And that was what, at least that sort of thinking and with that sort of background, that led me to my position on Citizens United. In my book, for those of you that read it, you'll see I do a good deal of comparisons on this issue as well to foreign countries, where they, you know, much good democratic countries. I mean, this book is not at all about countries that suppress speech all the time. We're talking about England, and in some cases in the book about Canada. Free countries that just go a different way than we've gone. But in England, for example, their general approach is an election is between two sides. When outsiders come in, especially if they have a lot of money, they can screw up everything. And so they put someone in jail who is, or fine her, because she runs an anti-abortion group and wants to distribute leaflets. And under English law, at that time, you couldn't spend more than £5 total, $7 then, in a campaign. If you were a third party, the parties could, but outsiders couldn't. And that's still the law, it's now £500. But I mean, it's just a very different way of looking at things. The way I look at it, which is the way our law now looks at it, is to say, we understand the problems, but we're not prepared to limit the speech.
Questions? Yes.
In the context of Facebook publications whereby Russian proxies were issuing massive communications, and now there are similar kinds of communications that are coming out through Twitter, where do you have any sense in terms of the right of
Do you have any sense of the right of somebody to publish in that context anonymously? Or do you think it's a sufficient remedy to simply say, oh, if the Russians want to smother Facebook with a point of view, as long as it says this is from Russia, that's fine? You have a perspective on that?
Yeah. It's a very, very important area, and indeed one of the most important First Amendment areas now is more broadly everything about Facebook and Google, et cetera. But my view is that the most important thing is that we know that there's public disclosure when we're talking about what RT has on or ads in Facebook, which are by their nature deceptive, I would say, simply because they come from Russia. I mean ads taking a position that one party might take in this country and be totally protected in taking. Yeah, I think a Russian-funded entity ought to be able to take that position, but I think it's very important that we know who they are and that that's what they're doing. And I think it's constitutional to require that sort of disclosure as well. In that respect, the 2 points. One, we have the same sort of issue arising in a different context about Facebook, because it's not the government that we do when it is the government. Facebook says and has a policy against certain racist speech, right? They make efforts. They don't do terrifically, but they try, and maybe they should try more. I think they should. The government couldn't do that. I mean, that would violate the First Amendment. We protect racist speech in America, we do. But Facebook can make its own decision the way the New York Times can about what to carry and what not to carry. Now, it happens to have certain legal risks when it does it, because under our federal communications law, Facebook, Google, etc., are all immune from being sued for libel and the like, precisely because they're not publishers. It's not them speaking. So the more they get involved with editorial policies, the more they start to risk losing what frees them from a great deal of potential legal liability. Nonetheless, I think they ought to lean a little bit more in the direction of more disclosure. And I think they should lean more in the direction of not carrying certain material. I mean, we saw this after Charlottesville, when all the large entities stopped carrying a neo-Nazi publication, which they had every right to do, and I think they were right to do. But it's just worth recalling that the speech that they're not carrying is protected by the First Amendment against the government. The First Amendment, of course, and the Bill of Rights, of course, applies only to the government. So you know, we wind up in this very interesting and important situation where we as citizens, because I mean, Facebook, as enormous as it is, you know, cares about what its subscribers want. And you know, we talk about more than 1 billion subscribers around the world. You know, they have some very, very important decisions to make. And we are subject to how they make them. Because, you know, I mean, the other way to say it is, we have a few very large corporations that are having a more and more of a dominant impact on how the world, including the United States, gets its news and what the news is. And that is simply a new reality. I mean, what Facebook carries is more important than any other editorial decision made by any other editorial carrying entity. And that they are a private entity and hence not subject to the public except public opinion. It makes it all the more important what standards they use.
One area where recent campaign finance law has permitted a good deal of regulation is disclosure requirements.
I've been very concerned with, as you talked about, the closing of the restrictions on people approaching patients going into abortion clinics. And they talk about in the decisions, you know, that these are people who have the right to the public sidewalk and the public plaza, and there are people who are entitled to express their views. But when it comes to the 9 members of the U.S. Supreme Court, they still feel that they should be protected from the public demonstrating on the plaza in front of their courthouse. And if you look at the difference in situation, the comfortable justices in their black robes are and their cushy chambers are being protected, while a woman who has been soul searching for the last 2 or 3 weeks and is distraught is being thrust upon by the fiat of the Supreme Court. And the Supreme Court even has security people, so you can't walk up to a justice walking down the street or sitting in a restaurant.
Yeah.
Why is sauce for the goose not good sauce for the gander? Aren't they being hypocrites?
Well, here's my answer. Yes. I think it is indefensible that they take that position and have embodied it in their rulings. I also think that there should be more in the way of public disclosure via television and at least simultaneous audio carrying of Supreme Court arguments. We are starting to get more audio after the fact. Sometimes make you wait a week, but I remember one of the justices, I think it was Justice Souter, I'm not sure, who was heard to say that he didn't want to be recognized when he walked in at A&P. Well, you know, I get it.
I asked Scalia face to face, why don't you let your proceedings be televised? And he gave me the same answer. I want to walk down the street and have no one recognize me.
I mean, that's really, really unacceptable. So go and do something.
Hi, thank you for being here. Your book is fabulous. I forget the caption, but regarding the case the court will be hearing this year regarding the same-sex wedding and the baker out of Denver, in which, as I understand it, a First Amendment set aside the religion claim, but the freedom of expression arguing that baking is artistic, claiming that ought to trump the non-discrimination principles at issue. I'm wondering both what you think will happen and what you think should happen, and am I correct in thinking that if the baker should prevail, this would be the first time that a First Amendment claim has superseded a generally applicable anti-discrimination law?
Let me try the first one first.
Thank you.
I have to think about the second. Let me give the baker his due first. What is he saying? He's saying anybody can walk in my shop and buy anything off the rack, as it were, pre-made stuff. But I am, dash, dash, don't laugh, dash, an artist. I interview you. I talk to you. I get to know your family. I then create a wedding cake suitable for you. And just as you would not make an artist do a painting, you can't make me, or shouldn't be able to make me make the wedding cake. Now, that said, I think the First Amendment is not a defense. I think that when you have a store and you invite people into your store, you are subjecting yourself to laws of general application, including anti-discrimination ones. I think, for example, if a gallery in which they offered to paint portraits had a sign saying "No blacks allowed," everybody would understand right away, but that can't be protected by the First Amendment. And it's my view that it isn't and shouldn't be. And I'm probably going to join a brief saying that. As to whether this would be the first time, I really have to think about that. I just don't know.
Yeah, I can't recall a case where First Amendment's been a defense to a general anti-discrimination law.
Can you talk about what you think the future of the Citizens United case will bring to our political sphere?
We have a lot of data now about what has followed. I don't want to say because of, but we've had 2 presidential elections and 4 congressional elections since Citizens United. And so we have a lot of data as to where money is coming from. The overwhelming amount of money is from individuals. Overwhelming. I mean, it's like, and I'm so sorry I didn't bring these numbers with me, but over $1 billion is donated by individuals to, among other things, these super PACs and the like, or was in the 2015-16, what they call election cycle. The number from corporations is less than 100 million, and I think well less than 100 million. There's no more than 8%, and I think it is less. That's for a number of reasons which are obvious when you think about it. Michael Jordan used to explain why he didn't take positions on public issues by saying Republicans buy shoes too. And most corporations do not want to be center stage in political debates. And when one of them put in like $1,000 or $2,000 in opposition to a same-sex marriage referendum, they were picketed, they were boycotted, they apologized. It just isn't happening. Indeed, labor unions spend more money than corporations in the way that we are talking about now. That said, what has happened since Citizens United is that the amount of individuals who give money has decreased as the amount that the ones who do give money has increased. So we do have a rather small amount of people, call them even people and families, who give a great deal of money to call them political campaigns and the like, much more than previously, in each election, much more than previously. Also, as I said, fewer than previously. And so what that really raises is the correctness, and this is, let me say, the correctness of an earlier decision in this area, not Citizens United, but a case called Buckley versus Vallejo, a decision in the 1970s, in also campaign finance, but about individuals, in which the court concluded that individuals can participate as much as they want and are able to in political campaigns and therefore spend money, unlimited in amount, in political campaigns. The court said we're not going to accept the notion of equalization to make everybody closer to being equal in terms of electoral power through money. That notion of limiting speech of some, and they did analogize spending money on campaigns to speech, limiting speech of some to equalize it to others, they said is alien to the First Amendment. So that case was very controversial. It really was the Citizens United of its time. Law professors hated it as they hate Citizens United. It wasn't an affront to the public in the sense that Citizens United is. Citizens United is one of the few things that brings our country together. 80% of Democrats and Republicans disapprove of Citizens United. Now, I have my own views as to why that's so, one of which is that the Democrats have run on it, and the Republicans who think they profit from it have found no reason to talk about it. So we've had what I believe is a one-sided discussion of it from the day it was issued. But whatever the reasons, I mean, where we are now is that now I don't think that the concern about corporate control of the country as a result of Citizens United is or ever will be borne out. Now, to be clear, corporations spend a lot of money on other things, lobbying. I mean, you know, and there are places they can spend money legally, and a lot of it, and they do. But it is nothing like this extraordinary amount of individual money that is spent. I mean, the largest individual contribution in 2016 was like $87 million actually by an environmentally conscious guy from California. But there's no doubt there's an enormous amount of money in the campaigns that some of the concerns that have led people to be upset about Citizens United will remain. A great amount of money, for the most part now, very clearly now, spent by a small amount of families and individuals and the like. And if one were simply approaching this as a public policy issue rather than what the First Amendment means and how it should play, one would ask that question: is there something we should try to do about that? The Supreme Court so far has said no. The First Amendment, as a part of allowing speech, allows spending on speech. Sorry.
I think one of the hidden costs of Citizens United is that there's not just Citizens United, it's the whole campaign finance jurisprudence of recent years, is that it puts so much pressure on every candidate to raise more money. You need the war chest, you're always afraid of somebody coming in at the last minute, and the amount of time candidates now spend in fundraising, I think has changed the whole nature of the representative-constituent relationship, and that's a huge cost, it seems to me.
Well, I'm so sorry, but we actually are out of time for questions from the audience, but the gentleman will be at the signing table afterwards, so if you're getting in line there along the hallway into the cafe, you can ask a good question. And thank you so much for coming.
Sure.